Director of Public Relations for Clayton-McCulloh, and I'd like to thank you for joining us this morning on this very special webinar on coronavirus. Good morning. My name is Arlene Ring. I'm the Director of Public Relations for Clayton-McCulloh, and I want to thank you all for joining us on this very special webinar on the coronavirus. Today, we have some very distinguished guests who are very knowledgeable on this subject. We have Brad Pomp, he's President of Sentry Management, and Neal McCulloh, one of the senior partners at Clayton-McCulloh. We do ask you to hold your questions until the end, where it's time for question and answer. When you do submit your questions, when you type them in, please type in which speaker you want it addressed to, your name, your association or management company. And after going through all the questions and all the topics we have, we decided there are so many that we are going to do a follow-up seminar, and we will send out another mass mailer to let everybody know when it is, so y'all can come and have more questions. If you didn't get your question answered, perhaps it'll be then. I'd like to go ahead and turn it over to our speakers.
Thank you, Arlene. Once again, my name is Brad Pomp. I'm the President of Sentry Management. Sentry focuses on homeowners association, condo association management. We operate here in Florida primarily in 16 markets. Thank you for having us.
And I'm Neal McCulloh. I'm one of the senior partners, as Arlene said, in Clayton-McCulloh. And this is the area of law we do. We do association law. And for today's webinar, the whole point is this is in the nature of a public service that we're trying to do for you. There are so many questions, and the change of the law and the change of what the associations have to react to is so immense and so sudden that we thought that this was necessary. We are very, very appreciative of Brad and Sentry joining us to be able to get you this information. Unfortunately, as Arlene said, there are so many people attending and there are so many questions, we will not be able to get to all of them. For that, we apologize, but we're going to try to cover the topics which will address your questions the best. And as Arlene said, we'll try to do another one of these so more questions can be answered. And with that, back to you.
Thank you, Neal. So as Neal and I prepared for this conversation, one element became obvious that really was a single strand that wove throughout almost every topic that we'll cover today, and that's communication. And it seems like an obvious statement, but really we've seen the difference between great communications that boards are having and some that are challenged in that area. And so we want to encourage that great communication across all that you're doing, not just with your members, but make sure that all of the folks that are supporting you, whether it's your management company, your association attorney, your vendors that support the communities, are all on the same page, and that's going to happen best through communication. And so there's some areas that I want to touch on that really allow for better communication and set a great baseline for that communication from the board to all those partners and homeowners. First and foremost, I would encourage you to have an official channel. Make sure that homeowners know what that official channel is and that they're receiving the communications from the board through that official channel. And so that can come in several formats. First, and my preference is really if you have a great email list for communities. Typically with larger communities, that's a challenge. But with some smaller communities, you know that you've got a great email list, you've got contact information for every unit owner, and that seems to be the best format. Some other great formats are the formats that boards control the information and can control the message entirely. So that may be a website that the board has oversight of and doesn't take in other communications from homeowners. Certainly there's typically a central point where folks may post physically communications, but in these times there's a lot of owners that aren't going to those common spaces to review those communications that are posted. And so understanding that official channel is great. Now some communities don't have those benefits, so they might have a Facebook page or other social media. And these are areas you've got to be a little bit careful when you post information through those mediums as official communications from the board and delivering decisions by the board. And so one, you need to make sure that you are identifying it as an official communication, put it in a format that it's clearly an official communication by the board. So it may be saved as a picture, it's put up with a board letterhead signed by multiple board members, and that way the homeowners understand those are the items that they need to attend to. In social media, if you have the ability right now to turn off some of the chatter that may come from homeowners, I know that may be unpopular, but you want to make sure the official message through the official channels are coming through. You also want to really set a cadence around those communications through those official channels. Let homeowners know every Tuesday the board is going to issue an update, and it may come more frequently, but at least every Tuesday or every Thursday or every other week. It depends on how frequent you believe is appropriate for your community that something is getting posted, but that way they know to look for it. An important piece around that is it's okay to post there are no updates. We're continuing to work under the status of the last official notice by the board, but filling that void that homeowners and community members aren't wondering what's going on and what policies and procedures they need to follow is important. The second I would tell you is transparency. Often boards will put out there what the decision is, and certainly that's important. But the great communications include the why and the when, and answer those questions for the community members, because they want to understand what's going on. And for the board to include, hey, this decision was made on April 1st as an example, and it was made for these reasons, both as a community, but also some outside factors, and you should recognize and reference public orders that have put out there. Municipalities may place some orders out there. The governor has placed an order out there. The CDC has guidelines that need to be followed, and referencing those in your communications is often the why, and will prevent you from having to put a second communication explaining why the board did something. So as much transparency that you can have around decisions that you've made is important. I would also encourage you to have time frames in that transparency, so that it includes information such as the board has made a decision. The decision begins on April, the policy begins on April 1st and carries through until July 1 unless otherwise notified. Come July or come a date earlier than that, if you feel like you need to extend it, that's okay. But at least they understand the time frame that's in place. At the very least, put in until otherwise, updated. In terms of credibility, start with that official channel. Start with transparency. But to be credible, I would highly encourage you to communicate a decision that the board wants to make with your association attorney. If you have a management company, lean on your management company and their experience. I will tell you, we have the good fortune of working with a lot of communities, and frankly, we see the communities are doing it well and have best practices. We also see communities that are struggling in this area, and they're not putting out good communications, and our goal is to help you do that. So if you have a communication committee, review those, and your committee should include your management company, your association attorney. I would also suggest, as much as this seems like the simple stuff, please make sure it's grammatically correct, it's spelled correctly. If you want to lose credibility with your board, with your community members, that's a quick way to do it. So have multiple people, review it before you send it out. The last thing I would suggest is, right now it's difficult to over-communicate, but you still need to be respectful of members' time. And so once again, get on a proper cadence of when you're going to communicate and how you're going to communicate versus trying to send something out on a daily or everyday basis. Do you have anything to add there?
No, I think with that, we'll move on to next topics. We have so much to cover. My next topic that I'm going to cover is closing the common areas. A lot of you have already done that. In doing that, though, we want to talk for a second for those of you that have done it or may need to do more of it, as well as for those that haven't engaged in this at all. First of all, I want to talk about the owner's rights versus the board responsibility. Now, notice there are two diametrically opposed potential things that are out there. Owners generally have rights to use the common areas and the common elements. In fact, they're generally an easement right, which is a highly, highly protected, constitutionally protected right. Nevertheless, that right needs to give way when certain things come into play. What is the most important thing for the boards to be considering? Well, in our opinion, the most important thing to be considering is the health, safety, and welfare of your owners and your residents. Therefore, when we watch what the government is doing in terms of closing down areas, basically almost demanding that people utilize social distancing, we should be employing the same type of practices to protect our residents. That's primarily the thing that we want to put out there for our associations and for people out there to consider doing. In doing that, what are the board's rights? Well, the board has a lot of rights, especially now. Right now, what the association has done, or what I should say the government has done, is they've relaxed the restrictions on emergency powers. Under the different types of associations, whether you're talking condo, HOA, co-op, etc., on each of those, they all have emergency powers under their acts, under the statutes. Those have been relaxed. Those used to only be available in the event damage occurred. Essentially, they were instituted to deal with hurricanes. However, those have been relaxed, and boards should be taking advantage of that power that they have always probably had in their emergency situations, but has essentially been codified at this point. As such, one of the things that we're going to suggest is that you enact and close common areas that are open for multiple use. Basically, what we're talking here is where people will congregate. In fact, and I'm going to use one of the Orange County ones as an example. What are they closing? They're closing their fitness centers, gyms, game rooms, tennis courts, playgrounds, basketball courts, volleyball courts, boat ramps, canoe/kayak launches, splash pads, and pools. Therefore, those are the type of areas where people will congregate, and we are recommending, we think associations should be cognizant that they want to restrict the use of those areas to protect their residents. Notice that right there, one of the big ones that's out there and people have a lot of questions on is pools. Are we in favor of closing pools? The answer is yes. People congregate at pools. We can say, well, you can have social distancing in pools. Yes. How effective is that? How many people are going to comply? How often will people lose track of their distance? How many items around the pool will they touch? Will they touch the guardrail going in? These are the type of things. I hope everybody heard tennis courts. You go, well, wait a minute. They're social distancing by nature. Yes, but you have to unlock the gate, touch the gate. You're touching the balls. Therefore, these type of areas probably should be restricted as to use by the board. In doing that, we will talk later about doing board meetings and how to do it. With respect to that, that's one of the things that we will talk about, how to enact these rules to give you greater credibility as well as to reduce challenges. Now, the next thing is justifying that right. When you do this, you probably are going to want a special motion drafted which delineates why you're doing it. Explain to the members. It goes in conjunction with what Brad was just talking about with credibility and communication. You want to build your credibility. Therefore, if you explain this, it may reduce why. Point out that, of course, the state of Florida has been declared by the governor to have a state of emergency, go into all the reasons behind the need for this, that we have a pandemic, and then your attorney can help you craft the language that you may want to use both for the motion and the notice to your owners. Notice that I did put notice to the owners. Back to what Brad was saying on the communication aspect. Once you pass this, it's great to be able to disseminate this by email, as Brad said. You may need other things. You probably are also going to want a post notice. With respect to closing common areas, think through the different type of common areas, and on some of them you may not be able to prohibit their use. You may have to consider restricting their use. What about in a high-rise condominium where you have an elevator? What do? You're not going to tell people to walk down 7 floors, even though it's an area where people can congregate or be forced to be in very closed, confined spaces. What about restricting the use of the elevator to 1 person at a time? Okay, maybe a good idea for the elevator. In doing that, what about if they have to have a healthcare professional with them? What if they also have to have, like, potentially, in addition to a healthcare professional, what about family members because they're in the same house? So you may open it up to those latitudes in terms of only 1 person except for these instances. All right, so the different types of areas may require different types of restrictions. And then the next issue on this is the credibility of the board. Part of that credibility is through the communication. Part of it is by explanation, okay? Part of it is by dissemination of the information. So in those areas, I think you're also going to want a post notice. And with that, we've got so much to cover. Back to you, Brad.
So if I could fill in there, when you're putting out those notices, you know, Neal may have better information than I do, but they truly need to be in an open and obvious area. Mm-hmm. And somebody probably needs to go back and make sure that the posting is still there on some sort of regular routine, whether it's a board member or a community manager, checking it every so often to make sure that that posting didn't somehow get mistakenly taken down. So I'd like to talk a little bit about committees and the board meetings as a whole, and then Neal will go in a little more in terms of the legalities around that. But just in general, boards are asking, should they continue to meet? And really, from our position, the board has a fiduciary responsibility to continue to meet and continue to do the business of the community. And so really it's a matter of what needs addressing now and what might need addressing or could be addressed at a later point. So if you haven't made decisions on amenities, I would highly recommend it, and as Neal just talked about, highly recommend you get together and make those decisions now if you haven't already. Communications to homeowners, once again, it's critical the speed at which those types of things need to happen. And soon your board will be discussing assessment management and collections as the economy continues to have an impact on all of us. So what can wait, right? And so if you've got some large capital projects that you haven't started yet, if you have a landscaping decision, a change of landscaping, those are the types of things you might be able to put off a little bit and shorten your agenda so that you can focus on the coronavirus. But my recommendation to you would be, don't just table them. Maybe try and let homeowners know a specific date that you're going to readdress them. Let them know it's been added to, for example, the August agenda. And that way, if they're passionate about it, they know when it's going to be addressed and when they can come back and include their ideas to the board. So not a matter of if you're going to meet, it's a matter of how and what manner you're going to meet. And so we're all learning a little more right now about GoToMeeting, Teams, Zoom, and lots of other softwares that allow us to have better communications as a group, particularly allowing us to see each other and have teleconferences. I think that connection point versus just hearing each other is really very important. And so, having that ability, for us, we've implemented it with all of our managers. I suspect most of your management companies have identified some platform that they can have those communications. And as you start to implement those platforms, I would highly suggest that you take a few minutes in advance and figure out how you're going to facilitate those meetings as well and as professional as that you do a regular board meeting, because it's different. Talking over each other comes much more apparent when you have multiple parties talking through telephones, and so how you facilitate those and how you make those go as smoothly as possible is going to be important, and communicating that at the beginning of the meeting that it's different. But I will tell you, we've had some boards come back and say, they've actually had some of their most focused meetings because people understand the severity of what's at hand, and they understand that it's a different medium than meeting in person. So let me talk about a couple of, actually let me add one more component about the technology. I would recommend, and Neal may have some concerns about it, but I would recommend doing a dry run on the technology with your full board and get everybody together. And as a best practice, make sure everybody understands right up front, there'll be no discussion of board business and community business, that the sole purpose of that is to get everybody logged in from their home, from their technology right up front. And then we've even had a few boards document in the next set of meetings that there was a gathering to simply test the technology and there was no community business discussed and everybody immediately logged off. But you don't want the first 15 minutes of your board meeting to be around getting the technology to work. So let me talk about a couple of committees real quick, and generally maybe they apply to committees as a whole, but the Architectural Review Committee, that's a committee most communities have, and some are having some challenges getting together right now. And so the business of the Architectural Review Committee needs to continue just like the board, making sure that in some way those applications are getting reviewed. And so if possible, still use technology to do that. I recognize the challenges around it, but I have seen in my neighborhood quite a few roofs getting replaced right now, homes getting painted. People are home, and those, a lot of construction trades are considered essential businesses, and they're allowed to continue. And so you may even get an uptick in some applications. Now, the challenge might be if the board can't get together quite yet, or the Architectural Review Board, It may not be a bad practice, particularly if there's a deadline on when they have to be reviewed by, to explain to the community that you can't review it in that timeline, so that you are rejecting the application, but you're rejecting it with the hope that they will resubmit it, and it's being rejected as a formality until the board can properly meet and review the application, and the goal remains to be doing that as timely as possible. But once again, a communication piece is going to be important because they need to understand why it's getting rejected, and it's only temporary until they resubmit. The violations committee or the fining committee, we've had folks ask if they really should stop that function. I don't encourage that practice, and certainly that comes with a little bit of controversy as everybody's on edge a little bit right now. But I will tell you, there are some possible considerations that you could take. Why do I not encourage such a practice? Homeowners still need to know that the board's going to continue to do their business, and the community still has covenants to follow, and everybody needs to be in accordance with those. And not attending to that is really not acceptable. An area that you could help them with, though, is, hey, this typically would have a 30-day cure period. We're going to extend the cure period to 60 or 90 days so that you have a longer period to do it, but you also know that it has to be done. You have to appreciate there's a lot of folks that don't want to go to Home Depot or Lowe's right now and get the wood that they need to repair their fence. And so be respectful of that, be neighborly of that, but also make sure that they know they still got to get it fixed. And then, we've had some social committees that have just kind of shut down. Often with a social committee, we associate that with people being together. And right now we can't do that. But I will tell you, typically the social committee brings a positive message. And it's important that communities continue to get those positive messages and have some way to continue to connect. And so we've seen communities have, sidewalk chalk art contests, and we've had some do Thursday night dinner in the driveway, and, the families wave at each other. And if there is a way, for the communities to come together, because it's during these tough times, hurricanes and similar, that you really see the communities at their best. And I think if the social community can engage folks a little bit, that can only help.
Okay, one thing I just want to comment, and it's basically just to reiterate, part of the problems that we are very concerned of are the requirements of the documents that we need to fulfill. And Brad hit on it very well, and that has to deal with like the ARC committee. A lot of your documents say that if someone submits an ARC application and you fail to turn it down within 30 days, it's deemed approved. Be very careful of that one, especially, unfortunately, there's some people out there that will take advantage of this situation. Therefore, it's important, if at all possible, to hold that meeting, and you probably can. The ARC committee may be able to meet. So my next topic deals with literally the association meetings.
I'm sorry to cut you off. Can I add one more interesting statistic? Our community managers' emails have gone up exponentially during this time. And one item that's come out of that I meant to mention is they're getting a tremendous increase in email from homeowners reporting other homeowners because folks are home right now and they're walking around their community. It's their one opportunity to get out. The board may really want to remind folks, hey, we appreciate it. Let's all be neighborly, but the management company or the board is still doing their job, and they will attend to those items, and they don't need neighbors reporting other neighbors during this time. Sorry, Neal.
No problem. So the other thing that what I wanted to talk about, and it dovetails into what Brad was saying, is the need to probably continue to hold your meetings. Well, how do you do that? Don't forget that for our board meetings, the owners have the right to attend and speak on any agenda topic and any other topic which the board opens up the meeting for to discuss. Therefore, because of that, how does the board address that legal right and that legal responsibility? Well, as Brad said, a lot of this is being done telephonically by GoToMeetings and all these other facilities that are out there that you can use. However, with respect to that, do we invite the membership to participate in that? In part, that depends on the technology that you have. It's probably a decision that the association and the boards are going to have to make with what is the priority, what is the higher duty. Associations are corporations. You need to get your business done. So you're probably not going to be able to just say, hey, we postpone things forever. And yes, you are allowed to postpone things currently. That's not a problem. Whether you should is a different matter. Because of that, one of the things you do want to do is try to facilitate the owners being able to attend and have input. If you can, include them in the conference call. Let them dial in. Have your notice point out that they will not be able to attend in person. However, they can dial in just like the other board members, and here's the dial-in information. Great. Now you've done that. Unfortunately, a lot of times you will have people that want to constantly talk, interrupt the board, and you've got to get through the board business. Therefore, if your technology permits, one of the things you want to consider is letting it set forth where each of the owners, not the board members, are muted. And then when it gets time for the owners to be able to speak, to unmute them. The other thing you may want to do is schedule 2 board meetings. Board meeting 1 is for where everybody is on the same conference call, meaning the owners are allowed to participate. But what happens if it goes sour? What happens if the board can't talk because the owners are interrupting all the time? In that case, you still need to get the board business done, and you may want to essentially shift to another go-to meeting or another call-in number so that they can get the business done, which brings me to my next point. What if you don't have the technology? Well, in that event, how about you put out there to the people in your notice, we're going to have a board meeting, owners can't attend, but to facilitate owner input, please deliver your emails to the association manager on or before blank time at blank date with the information you want to impart to them. What have you done? You've done the best you can to allow their participation and then report back to them what's occurred and why. Now, the other thing that comes out of that is, great, what about noticing? Well, we want to the degree we can, facilitate the required notice. What if you can't wait? What if there's an emergency situation? Then act. Who should act? To the degree you can call a board meeting rather than leave it on the president or the manager, call the board meeting. Do it as an emergency if you have to, but it's better to have a consensus of the board than to have a unilateral person acting. However, what about a unilateral person acting? We prefer that there's been a delegation of authority. You've heard me talk about earlier about the government basically acknowledging that there's emergency powers out there. What if we go ahead and delegate to like the president or 1 or 2 people the ability to act with respect to the coronavirus and any matters that they believe to be of essential need for the association, which cannot wait? What if we delegate that power directly to them immediately? Then you have the ability to go ahead and deal with it. Now, the reason that I talk about all the stuff that I just went through, and one of the things I hope to talk about several times today, is the fiduciary duty. Now, the boards of directors and management, by the way, the law firms, all have a fiduciary duty, highest duty imposed by law. There is no higher duty. That's what we're trying to fulfill. That's what we want you to fulfill to the degree you can. But that doesn't mean because you can't meet a standard like having the owners attend in person or even participate if your technology doesn't allow it, that duty supersedes the duty to get your business done and otherwise protect your community. You guys do need to get things done. The ARC committee, if you can meet. Don't postpone it. I totally agree with Brad that if there's no way for the ARC committee to make a decision, it is better to formally disapprove and advise the applicant that their requested alteration has been disapproved formally to comply with the requirements in the documents than to not address it at all. I would also recommend, back to communication and credibility, that you put that notice out to everybody if you're not going to be able to deal with it within the 30 days, that is being suspended by the board of directors as an emergency situation and that you will reconsider. However, the best line is if you can meet, do it within the time criteria. We recommend that first. And with that, back to you, Brad.
Thank you. So let's discuss emergency plans a little bit. And we've had several communities say, well, we just didn't have an emergency plan, so we don't need one. And certainly some of this is what's in place, but also I would tell you it's still important to get one in place if you don't have it. I will tell you also, I haven't come across one community yet that had an emergency pandemic plan in place when this started. A lot of hurricane plans and natural disaster plans. If you had one, I'd love to know because you will win the Blue Ribbon Award for preparedness. Anyway, So where to start if you don't have an emergency plan? I would tell you the first place I would look is kind of internally. Are there areas that during past, emergencies, certainly here in Florida, we do have the regular unfortunate occasion of hurricanes. And so in the past, if you have not maybe performed as well, or your board, previous board didn't perform as well as the community had hoped in terms of communicating, in terms of proactive actions, that's where you start. You know where the community's tripped up in the past. So go ahead and start getting those things in place and have quick action. But I would tell you, one piece that I think is important to communicate to everybody is there's one regard that this is no different than a natural disaster. Excuse me, when we have a natural disaster, when we have a hurricane, you see everyone in the community jumping in. You see people out boarding up their windows. You see people picking up debris around their homes so that debris doesn't become a hazard. And everybody works together to make sure that not only their property is safe, but the surrounding area is safe. And this is no different. A little bit different items that we have to work on together, but really reinforcing with the community that it's only going to work if we all do it. And, instead of talking about picking up, debris in the yard, we're talking about washing hands and touching as few pieces and places in the common area as possible, and doing it with safety in mind and wearing face masks. But if only one person's doing it, it's not going to work. And reinforcing that togetherness as a community really, really is important. So where do you start? Obviously, if you do have a plan and you've had a plan in the past, dust it off, because I suspect the first paragraph in your plans talks about communication. And yeah, I know that's a recurring theme, but follow that communication plan in terms of how you talk to your community managers and get information out there. One kind of interesting piece that is a reverse of what we typically see during an emergency. Here in Florida, most of those emergencies are hurricanes, and you see an evacuation out of Florida. Well, we've seen the exact opposite. We've almost seen a reverse evacuation as people come to Florida to their vacation homes and to their snowbird homes. Well, that's, they're coming from hot spots, and that's brought new challenges for Florida. And in fact, because of that, we've turned a bit into a hot spot. But communicating to folks up front that, hey, there's a governor's order, and if you do come from out of state, you are required to self-quarantine in this community for 17 days. And making sure that folks know that in advance, that they have the appropriate food for that, that they stay self-quarantined is a great communication as part of your emergency plan as we get more people coming into the state that have homes here. We've had some communities put out some great checklists, just like they do during a hurricane, is putting out checklists for the communities to follow. One interesting item that I've seen went out that I haven't seen any other communities do it, but I think it's great practice, really on just a public service point of view, and it falls under emergency plan, is letting homeowners know where the closest coronavirus testing site is. If you have a homeowner that's starting to fall ill, they need to know where to go. I've seen signs at Walgreens and Targets that say they're not a testing site, and it tells me there's people going to the wrong location. They don't know where to go. They're going to pharmacies to get tested, and letting people know where to go is really important, because you want them to know if they've fallen ill so that you can take action for your community. And then from there, I'm going to talk about guest access a little bit more in a few minutes. That needs to be part of your emergency plan that gets communicated. Vendor access, we'll talk about that a little more in depth in a few minutes. That needs to be part of your emergency plan that gets communicated. But I will tell you what might be the most important piece of what you add to your emergency plan, and to take action on now, or at least make decisions on now, are the actions you will take if a member in your community, particularly a condominium, falls ill of coronavirus, and how you will walk that fine line of personal privacy issues as well as safeguard for the community as a whole. Certainly there's some legal components there. I'd highly recommend any plan that you put in place that you review with your association attorney in advance, so that you're not tripping up over some very delicate issues about personal privacy, personal equal protection, Fair Housing Act. There's a lot of legal issues that really need to be attended to in such an item. But nonetheless, you don't want to be making an emotional decision once somebody is identified as having a positive test in your community. Thanks.
Great. Next one I'm going to talk a little bit about collections and covenant enforcement. As a predicate to going there, though, I want to go back up to the closing of common areas for 1 second. And this is to lay a foundation. While you heard me earlier talk about the ability to close to a degree, the recommendation to probably close and to put the health, safety, and welfare of your residents first, one of the things I didn't discuss, and it's a good point to discuss it now, is the associations and the board's rights versus their duty. The association probably at this juncture doesn't have necessarily a duty to close the common elements, but they probably have the right to do it. That's what we were addressing earlier. However, even if you don't have the duty, depending on what happens, you can have risk. You can have legal risk, and you can have practical risk. So we can talk about all day long about anybody can sue anybody else at any time over anything. And therefore, if someone gets a coronavirus, who knows whether you'll get sued. But that's not the main one we want to focus on. As you all have all seen with respect to the backbiting and the stuff, all the political stuff that's going on, everybody keeps getting blamed. You should have done more. You knew more. What you knew should have caused you to do X. And one of the things that Brad just hit on, and I'm going to hit on it a little bit later, is infected individuals in the community. However, when you're dealing with this, a lot of this deals with rights versus duties, and when do you exercise those rights? Again, the health, safety, and welfare probably comes first, and that's why we are recommending to our association clients that they really do consider closing the areas where people will congregate. Let's benchmark that into going to collections now, as well as covenant enforcement. Now, a lot of you may have seen some stuff out there where people and Community Association Institute, law firms are saying, hold off. We don't ascribe to that. And it's funny, when Brad and I first met about doing this, one of the things I thought they may take that position. No, because I understand if they don't. Point that we're getting at here is what is happening. First of all, with respect to holding off on collections or even covenant enforcement at this point, what's happened at least today and are not the violations and the lack of payment probably due to the coronavirus. Yes, that's coming down the pike. Yes, it may have hit to a limited degree, but most of those that are in progress right now have nothing to do with the coronavirus. That's first. Second of all, and most importantly, you need to understand that the finances and the collection of your funds is the lifeblood of your community. You will need to operate irrespective of the coronavirus. You will have bills and expenses irrespective of the coronavirus. Because of that, you need to consider, wait a minute, do we just now give grace to everybody? How long can we last? Can we do this? And what's the practical effect if we do? Do not forget, just because you give grace to someone doesn't mean you don't have those bills. Understand also that if you have at least a significant percentage of people not paying, the bills don't go away. Where do you now generate that loss of income? You generate it by going back to the people that have paid and put a greater burden on them, which is not fair. Part of this is just doing what's equitable and fair. Therefore, no, we do not recommend forestalling proceeding with collections. And in fact, while you might want to give more grace, and we endorsed what Brad said with the concept of, hey, on covenant enforcement, they give them more time. That doesn't mean they're allowed to just holistically violate. Two different things. And on the collection aspect, understand that there are limitations at this point. Yes, mortgage foreclosures can't go forward. However, with respect to that, understand I just said mortgage foreclosures, not the association's lien foreclosures. However, quite frankly, with respect to new cases, you're probably precluded from that anyway because of the fact that they're limiting or, quite frankly, precluding process servers from this point from going forward. So the new cases are going to slow down in terms of the actual lawsuits. That does not mean that the management company's role in terms of sending out their demand letters and maybe even escalating it, not even maybe, recommend escalating it to the attorneys, but not going probably past the point where you file the suit. by going ahead and doing that, you may also be doing them a favor. Don't forget that while they're not paying, they will be getting interest and late charges and other charges, which will become more difficult for an individual to pay if they forestall paying it now. You can say, well, we can forgive it. Really? What precedent are you doing if you do that? Remember that so much of this is a credibility game. And unfortunately, we have to be hard on this to a degree because our client is the corporate entity, the association, and we need to protect the corporation and the entity to be able to operate to service all of the owners and residents. You have to have funds to do that. And I assure you, all your vendors aren't going to be really happy when you sit there and say, well, we didn't bother to collect from our owners because of the coronavirus, so we can't pay you. That's going to become a problem. You don't want to do that, at least not in our estimation. So the other thing is, don't forget that you also go back to the fiduciary duty, highest duty imposed by law on the directors. The other thing you get to do for our clients, blame us. This is what we're saying. Blame us. Don't put yourselves on the hot seat by saying, okay, the board's just decided it. No, on advice of our counsel. Here is what we're doing. Okay, and then you can explain why. And most of the people, even though they want to be good Samaritans, will understand that if you let everybody stop paying, what's the practical outfall of that? The practical outfall of that is that, quite frankly, you're going to have more and more people not paying usually, and then the people that have already paid will have to pay more. Okay, so therefore, generally, you want to continue with your collection policies. That doesn't mean if someone has, hey, I've got a problem, they want to enter into a payment arrangement. Doesn't mean you can't make certain exceptions. It doesn't mean that you can't be humanitarian. It doesn't mean that you can't facilitate a methodology of having them pay. It just means you don't want to take your foot completely off the accelerator. Okay. With respect to covenant enforcement, Brad touched on this a little while ago. Yes, give grace. Let them have more time. But go ahead and follow your procedures to the degree you can, because of the fact that if you don't, are you hurting your credibility? And what happens when someone wants to or does something that is so obtrusive that you can't live with it? Now are you going to look like you're treating people unfairly and equitably? That's not what you want to do. By the way, before I go forward, in this video, by the way, every day I am wearing a mask to work, and you can tell that we're probably a little closer than 6 feet. The only reason we're doing this is to serve you. Our voice won't come across, and here's the distance that the camera and the room allows. So we're kind of forced to this, but we do encourage each of our board members to practice social distancing. We prefer that you do your board meetings, your committee meetings, all of your meetings by teleconferencing. We prefer that you don't show up. It's even a preference that we don't really even want 10 of you showing up or 5 of you showing up. Why? Consider utilizing the technology that's available to protect yourselves, which helps protect the residents in your community.
That's right. And in fact, this is the first day I've had to put a jacket on and a shirt in about a week and getting dressed up for the office. I actually had to shave, so I've been trying to self-distance here in my own home. But we do hope that you follow all the proper guidelines. Certainly, not only for the safety of your community, but really all of our social responsibility to try and move through this and get past it as soon as possible. So let me talk about one of the items that really is kind of coming up as one of the most sensitive items in an area that creates potentially the most disagreement and friction within a community, particularly condominiums that have some single access points. And that's going to be limiting guests and guests in your locations. And buildings. And so let me give you a real life example because I've had a relative calling me and asking for advice. My sister-in-law owns a condominium in Virginia Beach, and she's selling that condominium. And the only box she still needs to check to go to final closing, which they can do electronically, is have the appraiser come and visit the building. And the board will not allow it. It's the only thing that has to get done, and it's the only thing keeping her from selling her unit. And you can appreciate the fine line the board's trying to walk as it relates to overall community safety, but also there may be some liability there that the board's taking on because it goes beyond what the governor of Virginia has put in place. And so these are real decisions that your board and you have to make as you try and figure out what's best. And so, certainly, it goes without saying that you don't want to prohibit any first responders or caregivers coming into your community, but, that ought to be addressed. So what are some good guidelines? First and foremost, I would tell you, do not put a rule in place that you can't enforce. You will lose a lot of credibility very quickly if you do that. So if I went to kind of the extreme, if you had an HOA that is not gated and it's public streets, and to try and prevent access to folks coming into your community, really silly. I mean, that's not something you can enforce. People coming in really probably don't create an additional safety hazard if they're going directly to the home that they're visiting. So where you start to have more decision points is the more restrictive that the access points are. So in an HOA that is potentially gated and has amenities that are also gated. Typically pools have a gate around them. And certainly condominiums that have single point of access. In those areas, you've got some decisions to make. And as a board coming together and realizing that you've got to at least give some guidelines to the homeowners. And this is another area, it's fraught with landmines, and I would highly recommend that you review it with your association attorney before you put it in place. As you may have seen, maybe not, but for our purposes, the items that we review, the DBPR, the Department of Business and Professional Regulation here in Florida, is the governmental agency that oversees condos and HOA law and regulations. And so the secretary of that department, Halsey Bashirs, issued emergency order 2020-04, and Neal talked a little bit about what some of the government actions that have been taken. But essentially, that removes a lot of the limitations that boards have around emergency actions that they can take. And this covers both, or actually HOAs, it covers condos, and it covers co-ops and the laws there. And so, boards do have a responsibility to consider what they want to do as it relates to guests and restricting guests, and where those challenges come. And so as a couple of guidelines, one item that we're suggesting is you certainly don't want to restrict anyone that's coming, that particularly as it relates to a contractor that is there to make sure the unit is habitable. So if as a practical matter, it needs to have running water. It should have electricity. And if for some reason the unit does not have those items, you need to find out a way to get the contractor access so they do have those items. An area that is more challenging is under almost every order that's been placed out, executive order, that we've seen, not just in Florida, but across the country, construction trades are identified as a business that is essential business. And so they're exempt from a lot of these orders. And so homeowners and unit owners are leaning on that as the reason that they should be allowed to give access to those contractors. And really, and Neal may have a legal opinion on this, but from my perspective, those are apples and oranges decisions, right? Just because they're an essential business, just because they've been qualified as that, does not mean that they have legal right to access the building. That's a decision that the board needs to make as to who's going to come into the building and how they will have access. So what are some practical items to look at, in these difficult decisions as you want to be neighborly and allow folks to attend to the business in their unit that they need, and also consider the safety at hand. From my perspective, and certainly I'm a little biased in the discussion about the unit in Virginia, but it's really how sometimes that you will allow access. Certainly you don't want to have maybe as broad an access and as many people coming into your building as you would typically have. But the ones that you do believe that could come in safely is making sure that you have procedures in place that everyone follows, and it's well communicated that if you are going to have someone come in that fits a certain criteria and category, that this is how they're going to access the building. They have to wear a mask potentially. They have to wear gloves. You decide. But ultimately, it's more about how they're going to do so, then whether they can or cannot. But the boards will, it's an important piece for every board to consider.
Okay. My next topic is really stay-at-home orders, but it also dovetails into what Brad was just talking about in terms of limiting guests. One of the things I want to talk about, which was what Brad was hitting on, was it's a balancing that has to take place here. It's an evaluation of what right supersedes the other right, or what duty supersedes another duty. With respect to that, one of the things with people coming into your community and the board regulating those type of things that you need to consider is the owners have a degree of access and actual easement rights usually to have access in and to the building, not only for themselves, their family member and residents, but also for invitees, contractors, and stuff like that. Therefore, you have to have a pretty good reason to be able to say, no, you can't come, under any circumstance. And I want to focus on under any circumstance. What about limiting them? Yes. Evaluating them. Maybe on a case-by-case basis, but also if somebody really needs access for a reason, what about setting up protocols for them to access the building? They have to schedule a time. The association has to be aware of it. The association can have its maintenance person literally wipe down everything as the person goes in. Are they escorted from a distance? These type of protocols may also facilitate allowing a limited degree of access for those people that are necessary while precluding some that may not. But be very careful when you start to decide who may not be able to attend or not be able to gain access. Your real criteria for this is probably going to be the health, safety, and welfare of the public. But quite frankly, you can have argument as to what protocols can be implemented so that they can have access without denying, give them the access while protecting the community. What if they wear a mask? What if they wear gloves? What if they are escorted and with proper protocols, the maintenance is done to the areas they're in other words, spraying it down, wiping it down, etc. These are the things that on a case-by-case and item-by-item basis, I think you're going to want to get with your law firms so that when you implement these things, the particular facts make a difference. I mentioned earlier, and I'll talk about it a little bit more, about elevators, because I want to talk about when they're going in there. Are you wiping them down more frequently? So with that, though, I want to talk about the stay-at-home orders themselves. We now have, of course, in place for the state of Florida stay-at-home order, but we also have municipalities and stay-at-home orders, okay, for different cities, etc. Because of that, you're trying to comply with each. For the most part, they seem like they dovetail pretty well, but there can be some nuances. So let's talk about some of these essential services, which Brad mentioned a little bit ago, okay? Well, one of those that we're getting questions on, well, what about our gate guards? Yes, there's usually something that provides for police, security, etc. Therefore, under those guys, you may be able to do it. Also, because of their necessity for access, they also perform a lot of times an additional function. They are almost like an emergency responder, or not in the sense that they may be called and facilitate emergency response. So they, on general, I'm going to generally believe that they should be permitted, and they are a service that should be able to go to the communities and still be involved. Landscapers are almost always particularly recognized as a class of indispensable people, okay? management. Now the management and law firms, by the way, law firms are legal and generally we are, and management themselves are performing services. So yes, they are usually considered, in my opinion, generally going to be necessary personnel for the operation of your communities. However, that doesn't mean the manager should be on site. Two different things. Can the manager effectively perform off-site? If so, consider it. Also, how many managers do you have on site? We have communities with numerous managers. Do they all need to be there? Okay, communities like that, a lot of times the owners are used to going in person to go meet with the managers. Can we restrict it? Can we effectively do the business that would normally be done face-to-face over the phone? If so, try to do it. Minimize the contact to protect your staff and your community itself. These are the types of things that if you possibly can, you want to put in place, not just for board meetings, not just for ARC meetings, not just for finance committee meetings, but for management itself. But when you're doing that, it comes back to notifying the people, telling them how to get there, how to do things, being upfront and getting out proper notice of how things will be conducted. And then from there, you'll have to decide whether or not on-site management is necessary, etc. One last thing I wanted to talk about, and it's going back to that, having access to the community. And on, Brad's particular issue. On that issue, what is the risk to the association? Because they're denying this person to get in there. Well, the association can get sued. The association can get sued for intentional interference with contractual relationship. That sale may not go through because of the impediment that the association has put into place. Therefore, the association has risk. So I hope the association has evaluated that risk, particularly with its counsel, and determined, predicated on all the specific facts and circumstances. Notice I said specific facts and circumstances. Determine what's in the best interest of the association. That's from there. Brad?
Yeah, just a couple of points to add to the conversation, and Neal may feel differently about this, but from our perspective, the more restrictive your policy is on limiting guests, the more frequently you should review it. Now, it still should be reviewed on a regular basis. I don't mean let's review Tuesday, let's review Thursday, but if it's highly restrictive, I would suggest you're reviewing it on almost a weekly basis. Particularly as this arc hopefully flattens and starts to go down, it's tough to justify some of the reasoning, for the more restrictive nature of some of the policies we're seeing be put in place. So the second, just speaking about on-site managers, and that's a difficult one for us. Our communities, rely on the manager. So many people like to just go visit the manager and say hello. It's a part of their day. And our managers, frankly, that are on sites, they miss the interaction as well. And so, we do have a mix of managers, and I'm talking about on site, that are kind of dedicated to a community versus a portfolio manager that might have several communities. We have a mix where the managers are working from home, and the communities are finding ways to make that work. But then we also have a mix where we've put some pretty restrictive guidelines in place that they can be in the office, but they're not accepting visitors, right? And so they'll be in the office. They're there to take calls because it's a number that everybody knows. They're there on site in case they need to meet with vendors outside in an open air environment. And so just make sure you have a conversation with what works best about your community. And I suspect most management companies will work with you as long as it's safe for their employees. Let's talk a little bit about vendors. I can tell you this is a really challenging time for vendors that are coming to your communities. And I would highly recommend, because there are some vendors that are doing some phenomenal jobs in this time. They are figuring out a way to do it safe for your communities. And if you're seeing that, take a moment to thank your vendors that are out there working hard to make sure the business of your community is continuing. And so the other piece, once again, a common strand, is make sure that any kind of access restrictions you put in place or procedures and policies you put in place, excuse me, get communicated to your vendors. We've had a few incidences where homeowners understand the policies and procedures and the vendors don't. And so what happens is a vendor may be in an area of a building that they had no idea that they were no longer supposed to be in that part of the building. a homeowner came upon that vendor there, and the homeowner took action and felt that they had the responsibility to communicate it. And as you can appreciate, it became, kind of an unfortunate conversation pretty quick. So make sure you work with your vendors and let them know what policies are in place for your community so they can follow it and be sensitive to what you need. So part of the discussion, though, is also deciding what vendors you need to continue doing business at this time. And so, some of that certainly has some contractual components that you need to be sensitive to. If you have a contract with a vendor and your intention is to shut down work and potentially shut down the payments that go to those vendors, I would highly recommend you review those contracts. You have a discussion with your association attorney before you take action on that. So the better approach for us, though, is have a conversation with the vendor. Most of these vendors, they want long-term relationships, and they understand that we're in a temporary period here that may last somewhere, hopefully, between 60 and 120 days. And most of them will accommodate what you need. And having a conversation, have your manager have a conversation with them is really important. But I will tell you, in most instances, it's not good practice to just stop maintenance that a lot of these vendors do. As a really easy example here in Florida, particularly as the weather turns warmer, stopping maintenance of the pool and the regular upkeep of the pool is not a good idea. Not only that, it may be more expensive to get it back up and running at the time that you start to have folks be able to go back to that amenity. Also regular inspection of common mechanicals, whether it be, AC or elevator. I would not recommend stopping the reviews of those, making sure they're in good working order, and continuing operation for your unit owners and condominiums. So the biggest piece goes back to make sure your vendors understand what precautions, what protocols are in place. And then if you have if you're bringing on new vendors and you want them vetted differently than you have in the past because of coronavirus, and you have certain protocols that you want to make sure that they're following, that their employees are following, not only when they're on site, but when they're at other locations, let your manager know and make it part of the bid process so that it's included and all the vendors understand those are protocols they have to meet if they're going to come onto your property. And the last piece, as I said, talk to your vendors. Just like attorneys and management companies, they're visiting a lot of properties most likely. They see best practices, and frankly, they see some worst practices. And so they can probably give you some great advice in the areas that they work on.
Okay. My next topic is going to be back to delegation of authority and emergency powers, which I've covered quite a bit. So what I thought I would do is I'm going to touch on that again. Before I do, to flesh out this issue with who can come on the property and who is just deemed to be essential, personnel, et cetera. Understand what the state of Florida did, or the governor did, was adopt the Miami-Dade County Declaration of Local State of Emergency. So it literally incorporated, the state of Florida literally incorporated what Miami-Dade County did, okay, in terms of their stay-at-home order. So I'm going to read a couple of things from this so we can explain it so that you understand the basis of what Brad and I are talking about in terms of who does have access rights, because I'll talk about a lot of the questions that were submitted to us in the beginning hits on this issue, so I want to go ahead and cover it now. So that order basically lists as essential retail and commercial businesses which may remain open include contractors, other tradesmen, appliance repair personnel, exterminators, and other service providers who provide services that are necessary to maintaining the safety, sanitation, and essential operation of residents and other structures. Understand, that's pretty broad. So those are all those contractors. And did you notice essential operation of the residences? It's part of the reason we think management should be covered by this, all right? When you talk about other service providers, think of how broad that could be. So a lot of these people may be covered. So when you're asking us who can be there, one of the other questions that hit out, and I'm just going to go ahead and take it under this because it falls into this topic, is what about association employees? Well, if the manager, and it's an argument, doesn't say in the order that managers get to go, doesn't say that managers are excluded from the order. you have to read into the order and interpret the order, but that's what we believe managers should be included. I'm going to read another section of it, which also includes businesses that supply other essential businesses with support of supplies necessary to operate and which do not interact with the general public. So that's anybody that's a supplier, but there's, on that case, it's people that are not interacting. But you also have professional services such as legal accounting when necessary to assist in compliance with legally mandated activities. Okay, that falls that's where the law firms can fall under that one. And then you also have people that are, quite frankly, in support roles for those type of things. So that'll give you an idea of who potentially are not necessarily covered by the stay-at-home orders and can go to the association, etc. With that, I'm going to go back to the next topic, which is delegation of authority and emergency powers. We talked about this briefly earlier, and I can't stress it enough. This is evolving so fast. Every day there's new information, there's new issues that are arising, there are nuances, and quite frankly that means even our advice can change. How we approach things can change. Therefore, you want to have it set up, in our opinion, to where you can deal with things quickly. While we do recommend, as you heard me set forth earlier, board meetings. However, do you want to hold a board meeting every time something comes up? Do you want to delegate that authority to someone to be able to make a quick decision? If you do, though, we prefer that be done by a formal motion at a board meeting. Go ahead and set it up. Go ahead and delegate and give the rights under the statute for emergency powers, potentially to one or two individuals so that they can exercise it. Also, with respect to closures or limiting, or what about what Brad was just talking about in terms of people coming into the community or into a condominium? How do you deal with that? Do you want to be able, if a new circumstance comes up, do you want to hold a board meeting for it, or do you want to delegate that authority? I am not trying to suggest that you do not hold regular board meetings. I'm not trying to suggest that when you're going to be making an important decision, that be left on the shoulders of one individual. To the contrary, every time you can hold the board meetings and let it be a board vote, especially where you can have the membership in attendance, at least by conference call, and participating, that's the best. It's when you can't do that or when it's not timely that you want to have the flexibility to have someone that can make the decision now versus putting the association at risk for not moving forward and not addressing the needs of the community. So again, what do we recommend on all this stuff? We do recommend proper notice. Explain how you're going to hold your board meetings in the notice, whether by teleconference, etc. Point out how they can log in if they can log in, okay? In addition to logging in, if they can't log in, it will only be the board members because of limitations of technology or time, because you may need to hold a board meeting quicker than the 48 hours notice, etc. Then in that instance, make sure that you put notice out there. Once you've done it, what have you done? What were the decisions made and why? Build your credibility. Most people understand that a lot of the decisions or the decisions being made by the board are being necessitated because of the pandemic. Everybody has that. However, it doesn't hurt, and in fact, it's good if the membership understands going in the rationale and the reason for the board members holding an emergency meeting, for the board members making certain decisions to close off these common areas. Get with your attorneys, have them formulate the type of notices that should be put out, as well as not only for holding the board meetings and what will be considered, but also the notice to the membership of what those decisions are. In other words, what the restraints are going to be or the limitations, and most importantly, why. Justify the actions as much as you can so it reduces controversy and builds your credibility. Brad, you ready?
Yes. So Neal talked a little bit earlier, and there may be a little bit overlap here in my discussion about the financial reality and collections that may be coming as a result of the economic conditions we're in. The reality is, if you were watching at all any of the economic news, 10 million people in the last 2 weeks have filed for unemployment. Those are staggering numbers. Here in Florida, 350,000 people filed for unemployment in the last 2 weeks. Last year, the entire year, 307,000 people filed for unemployment. So in 2 weeks, we've exceeded the number that filed for unemployment all of last year. The unemployment system in Florida crashed because they'd seen volume that they'd never had before and didn't expect, and they're working on. And so, you know, not to continue down this road, but most economists feel that we're probably already at 10% unemployment rate. We went from 3.5% to 10% in a matter of a few weeks. And many feel that we may go to 15, 20, 25%, depending on how long this continues. Businesses are making some really, really tough decisions right now. And so your association's a business, and you're going to have some tough decisions to make in the days ahead, particularly decisions that affect neighbors and their homes. And so where we've looked at is how do we proactively work with our boards to get ahead of that curve and be ready as, you know, 30, 60, 90 days from now, some of the assessment collections start to lag. And where we're leaning is, you know, what lessons did we learn as a management company 10 years ago? Because a lot of the board members that are on boards now weren't on those boards 10 years ago, and they haven't gone through the economic crisis that we went through 10 years ago, and may not remember some of the lessons that we learned. And so let me kind of cover some of those. Once again, this is going to be high level. I highly recommend you work with your you know, your treasurer or your management company as you consider some of these. But first and foremost, you've got to monitor your cash flow. You've got to make sure that the association has the appropriate cash to continue the business. The reality exists that as some homeowners start to lose income, they'll place other bills in front of their HOA assessment. That's a reality that's coming. And so for you, as a board member, what are some leading indicators to consider? First, I would suggest you know how many months of cash flow that you have on hand. And the reason isn't to just know that number, but it's a number, excuse us, it's a number to track over the coming months in terms of if today you have 3 months of cash flow, but 6 months or 4 months from now you only have 1.5 months of cash flow, you'll see that you're spending cash at a faster pace than you're taking it in. Certainly watch the delinquency rate. That should be self-evident, or see that the accounts receivable is continuing to grow over time. And so those are areas to watch. Watch your variances on your budget to actual. A lot of boards, they set a budget at the beginning of the year, and then they just kind of look a little bit at the end of each month. You're going to have to be much more proactive, and one of the areas to really watch is those variances as you go through the course of the year. So steps to watch, just like if you ran, you know, your own private business. First is, I'm going to touch on expenses before I touch on income, but is you really ought to review now every budget item and determine if it's necessary as you go forward. Doesn't mean you stop it today, but you already have an idea and you have a plan in place of what's necessary and what's not necessary if you start to get into a cash shortage. Engage your vendors for solutions. I've talked about that a little bit. If you're starting to be a tighter you know, cash situation, talk to your vendors. Find out what services they could continue for a lesser rate as we all work through this over the coming months. Defer projects that haven't started. So if you have some projects that you can defer for 3 or 4 or 6 months, find out, are you going to be in as good a cash position in that time and have the ability to take on that project versus going ahead and continuing to jump in it now and then not be able to back out of it later. And then there's some areas that you may be taking on a greater expense now already, such as cleaning and janitorial, and you may have upped that considerably. Go ahead and start to make adjustments to your budget to actual, and you may have to find some other budget items to cut back on now to accommodate that. So that's on the expense side. On the income side, you know, I hope every association has a collection policy in place. If you don't, you need to have a written policy in place that's fairly executed across all homeowners and is clear and concise as to exactly what's going to happen if they stop making some of those assessment payments. You know, just right along with what Neal said, the board has a fiduciary responsibility to continue the business of the board and make sure that the community continues its operations. and certainly has a responsibility to maintain and enhance property values there. And if those maintenance items start to lag, it may have an impact on property values. So as it relates to your collection policy and coronavirus, I go back to some earlier comments I made and agree with Neal. I would not stop your assessment management processes. If you do want to consider adjustments to your collection process as it relates to the coronavirus, one, I would highly recommend those get communicated. I would highly recommend you have specific items that need to be in place in order for someone to qualify. And I would also highly recommend that you have a sunset on the period that those will be accepted. So, you decide, but maybe from April 1 to August 1. And if you get to August 1 and you need to extend it and your community has the ability to do that, that's great. But the assessment still needs to be paid at some point. But, make sure it's communicated, make sure it's fair, and make sure there's a sunset on the period that is in place. The reality of it, though, is, and I can tell you, we're starting to already see across the country, I've seen a couple in other Florida markets, not Orlando, where I'm at, is some news media reports where folks have received violations, not even assessment management or collection violations as it relates to what's going on in their home. And it's an easy target, HOA, to be the bad guy, when they send out violations during these times. Well, I can tell you the next step, and that we all need to be very careful of, is you don't want to be on the 6 o'clock news because you've placed a lien on someone's house that fell ill or lost a job as a result of coronavirus. And navigating those waters of continuing to get the assessments paid and being neighborly are some really challenging waters that you'll have. But there will be, I guarantee you, some folks that, they receive a lien notice and their first call is to the media. So encouraging homeowners to be proactive and contact the board, as Neal said, get a payment plan in place and letting them know the board wants to be friendly, but it's a whole lot better if they contact in advance versus just start missing payments.
My next topic was going to be infected individuals in the community. And I'm going to rifle through some of the issues I was going to discuss, but not take the time because it's taken so much time to get through things and we want to address questions. So in a second, I'm going to let Arlene direct us as to what questions are going to be taken or what she wants us to answer first. But before I do that, just one thing. Here's the things that we wanted to cover. And again, we're going to try to do another webinar, so I'll try to go more in depth in. But I wanted to discuss disclosure of names of individuals that are infected. By the way, preamble for that, don't do it. Next one, special protocols for those people that are infected. Back we talked about the elevator and those things. Releasing and publicizing names of infected individuals, that's one of the things. How do you deal with that? The health, safety, and welfare issues. What are you doing and the balancing of those things? The balancing deals with duty to protect versus individual rights. That goes back to privacy of the individual's rights. Use of common areas. But before I go to that one, just quickly, what do you do if the association, and I've actually had this question already, what do you do if it's been reported to the board that someone has it in your community, especially a high-rise condominium? What do you do? These are the things that you're going to need to get with your attorney on to make sure that you're navigating those waters properly and reducing risk to the association while maximizing the protections that you're affording your residents. And lastly, back to use of the common areas by such individuals, special limitations and requirements regarding that. So with that, what I'm going to do is turn it over to Arlene to direct us for what questions she wants us to take in what order. Although I will suggest that since we've talked about the pool issue and closing the common areas, as well as maybe doing the board meetings, skip over those.
So can I maybe ask the first question?
Sure.
Because it's in line with what you said. You talked about the communication to owners, and maybe it's more of just how the board considers, but I suspect there's a duty for them to report and potentially communicate it to external folks as well, that someone in the building has tested positive, whether it be the management company or other vendors that are coming into the building, that extra precautions may need to take place.
You're probably going to want to do that, but you said it very well. You said, once the person has tested positive, the bigger problem, you're going to deal with those. Those are going to be more clear cut. The bigger question that we're getting is, wait, someone said Mr. Smith has it, okay? A close friend, a relative. The board has no corroboration. It has no confirmation. This is secondhand knowledge. What do you do? Where is the board's rights versus duties? How do we adjust to balance the protection of that individual's privacy from the protection of the rest of the residents? And on that, I think you will be putting into place special protocols, as a precursor. Yes, I do, I like the more knowledge out. One, the more knowledge people can protect themselves. The more attuned the people are that there is an infected person within the community, the more they will adhere to the social protocols that are out there to protect themselves as well as others. By doing that, there will be greater efforts, okay? People may listen more to, hey, no more than one person in the elevator at a time, whereas other people without that knowledge may not. Problem is the board going to get pushed on all that stuff to, hey, who is the person? What is their unit number? These are the privacy issues which likewise must be addressed. And as part and parcel of that, again, the board should be holding meetings on what to do on this. In holding that meeting, what do you disclose? How far do you go? These are the issues that they really want to be discussing with their attorney and addressing those, because part of it's going to depend on a fact-by-fact basis. The other thing that's going to be happening there, in addition to the facts, is what is the type of community. Okay, a homeowner association where everybody has acre lots is very different to a high-rise condominium.
Okay, we're going to open it up to question and answers. We'll start with one of pre-submitted while y'all go ahead and type your questions in. Please put your name and your association.
Let's do cars. I want to do cars.
And which speaker you want it to go to. So we're going to take the first question, and it will be, I can't see.
And we're looking over here because there's a screen.
Yeah, we apologize. The screen is over here. Can I make a suggestion, Arlene? Let's do this. We got one from William Abdallah, Plantation Park. On this one, what are the state statutes regarding using reserve funds in an emergency to cover bills beyond those that the reserves address? Example, if a large portion of the owners did not make assessment payments for months, could you use the reserves to pay the salaries? The answer to that is, by statute, absolutely not. Okay? Now that we've said that, let's deal with some practical realities in history. If you all recall the hurricanes that hit Florida, when those hurricane hits, numerous, and I'm going to use condos as the example, numerous condominiums had their roofs torn off. And a lot of those condominiums were only part of the way through funding their reserves. So in those instances, you may have a roof with a life expectancy of 20 years that's only 3 years into its existence. So it's missing 17 years of payments into the reserve account to be able to fund the re-roofing. What do? The association in that instance is faced essentially with the same type of stuff we're facing today. It's an emergency. What is the priority? The statute says you can't use reserves for other purposes or even a different reserve purpose unless you get a vote of the majority of the members present in person or by proxy at a duly called meeting of the membership. Okay, that's basically the statute. So there's a limitation. The law expressly says you can't. I don't care. Why? Because you have an emergency. If you have a real emergency, and life and protection of property generally is going to take precedence over that vote. So when all this came down and all the condos used their reserves to pay for their roofs because they didn't have enough funds, and if they didn't, they were going to have water leaking in. They did have water leaking in. They were going to have the threat of toxic mold. So the board stepped up to the plate and said, we're going to use the reserve funds. What did the state do? Not a thing. Why? Because that was a higher caliber of priority. It needed to take precedence. Problem with the instances of what we're seeing today is, are we going to get to that emergency level? That's one. Number two, what actions have the associations taken up to that point? Did they cause their own emergency? Can that be factored into this decision? And could it place greater risk on the association because it didn't collect its funds? It didn't make an effort. It waived a bunch of charges. These are the risks that the associations face. If you get into a real emergency situation where you need the reserves, like on the roof, you're in a better position to do it. What do I recommend? Don't do it until you talk to your counsel. However, your counsel, depending on the situation at hand, may literally say it may be less risky to use the reserves and pay for some expense that's like an emergency or absolutely necessary than to not use the reserves. But that's going to be on a case-by-case, fact-by-fact basis, and you should consult your attorneys directly on that.
Sheila Powell has a question. Does a unit owner or resident have a responsibility to inform the board or management that they have tested positive?
Okay. Yeah. Okay. Does a unit owner or resident have a responsibility? Let's deal with moral versus legal. Okay, because we have to kind of break this one out. I know of nothing in the statute or the case law that delineates that. All right. From a moral perspective, yes. You also probably even want as part of your notice to the owners, and this is going to put a hardship on the association, the manager, and the board, and that is let people know that if they have contracted the virus, please let the association know. Why? Because the association should be trying to implement special protocols in that event. Think of the elevator example, and I'm sorry for the HOAs, it's just an easier example to use an elevator. In that instance, if that person's going to be using the elevator, do you want that person coordinating using the elevator with the association? Why? So other people aren't in the area, the vicinity when that happens. One. Number two, the elevator can be wiped down and disinfected immediately after the use. Three, the person exiting the elevator or pushing the buttons, that gets disinfected. What about the exit doors and things like that? By being able to put in special protocols for an individual that's been infected helps protect the rest of the community, and hopefully your owners and residents will want to do that. So I think you want to encourage it. No, I don't know of any law currently that mandates it.
Yeah, I would add, and it goes back to a point we made earlier about having protocols in place. Mm-hmm. And I think if you're going to communicate to your homeowners, one communication is the fact that you're sensitive to privacy issues. And that you hope that they will communicate it, and the board will adhere to the privacy issues. You'll make sure that, whatever privacy level that they are requesting will be met, but at the same time, you hope that from a moral responsibility point of view, they will let you know so that you can attend to the safety of the building, the people that are coming in the building, both unit owners as well as outside parties. But letting them know that you're sensitive to it in advance will give them a little more comfort, I hope, in sharing the information.
Our next question comes from Michael O'Neill of Country Walk HOA. Do you recommend locking open an unmanned gate to prevent roughly half the residents from having to touch the keypad? Gate is normally open down about 6 p.m. to 6 a.m. It is single access point for the neighborhood.
You want to go first? You want me to go first? Take your pick.
No, go ahead. Honestly, at the end of the day, I certainly have a recommendation. My recommendation is that I would not have it open and communicate to folks that it will remain closed, and you'll take some protocols in terms of how to continually clean that on a regular basis. But ultimately, those are the types of decisions that are before boards right now. They're realistic decisions that are there. Everybody understands that there's some real challenges that could be in place if they go up and touch those keypads. So knowing before they arrive at the keypad that they could maybe bring a paper towel with them or something so that as they touch those keypads, it's a little safer, or they wear gloves as they do it. But, if you have, gates in place, it's a no-win argument in your community. There's going to be people that say it should be left open for the safety of coronavirus. And there's going to be folks that tell you, hey, we moved here because those gates are locked at night.
Quite frankly, this is a balancing issue, and it's part of what Brad was just talking about. In doing this, though, there's another issue. Don't forget, earlier, some of the associations are sitting there now saying we don't want anybody entering. We don't want other contractors and personnel entering. So part of your balancing is once you open the gate, you've invited more people in than you previously had. That is not to suggest that that's necessarily the wrong decision, but it's going to, in part, depend upon the facts. Now, I concur just from the information that's on the screen, together with the limited amount of information we have and where we are currently with the coronavirus and the curve that we're on. No, I can't really recommend that you just open your gates. That, I think, right now may be problematic. It's not that you couldn't. This is a right versus a duty. And by the way, this could be affected by your documents, so your documents should be checked on this issue as well. But the other issue, it's back to the protocol. What can you do to try to effectively address the spread and infectiousness of the coronavirus while still maintaining the security that you have? What about, give an example, in our building where we're sitting right now, at our doors, when you walk in, there is a paper towel dispenser and there is a note, please use a paper towel to grab the handle. When you walk in the door, please discard the paper towel immediately. There's a exact same thing going out. You could literally have people either use paper towel or have disinfectant spray right there, all right, for people potentially to be able to use that keypad, all right? The other issue is the facts. All right, this is one gate. Do you have another man gate? Is this the only gate? These type of factors come into play, as well as potentially the curve of the coronavirus. As things escalate, greater and greater measures may be necessary to preclude the spread. But the other aspect of this is opening the gate may cause more and more people to come, open it up more to infection than by the infection being caused by people touching it. So right now, I can't really recommend that the gates remain open from the limited information that's been presented to us in the question.
Mike, who is president of Crystal Lake Community Association, his question is, they're scheduled to have their annual meeting in June. What are their options for delaying and or not meeting at all? Can we send our documents to them in lieu of a meeting?
Y'all go first about me. Go ahead.
Some of this is probably going to be a more legal question than it is just a pure management question. For me, just from a practical point of view, and Neal will probably talk to this more, is how long in advance do you have to notice the annual meeting? And so June's a little ways out. If it's a 30-day notice, I probably would wait a little bit before you cancel it. We're still in early April. One potential good communication is to go ahead and set an alternative date that is 30 or 60 days further out. Once again, a lot of this relies on what's allowable in the documents, which I'll let Neal speak to, but really communicating it, letting the community know that you want to have that meeting, that it's not quite time yet to cancel the meeting because, you know, you have to have a 30 or, 45-day notice, whatever the case may be. But, that positive communication, and then going ahead and letting them know, reserve this date in the event that we do need to cancel.
One, yes, in my opinion, you absolutely can postpone it, okay? That's coming down by about everybody. On top of that, it's probably an emergency and necessary matter. Part of the problem you have with a lot of the associations is literally holding the meeting, people attending. How do you effectively do it? Think of the proxy aspects, and this is maybe we'll even do part of this on the next one. But like for associations where you can use a proxy to vote, now this is mostly going to be the owner associations, or even for condos, getting a sufficient attendance, all right, to open the meeting, except for at least our condo electing directors. With respect to that, what you say, well, we can have the proxy go to the president. No problem, and he can be the only one there in person attending the meeting. What if Mr. Smith doesn't want the president to be his proxy? Can you force another person to be able to go in person to the meeting? How do you cast that vote? These are all of the issues that are facing associations today. Therefore, in my opinion, you absolutely can postpone that meeting. But I do agree with postponing it, not just saying we're going to skip a year, okay? Additionally, like with what Brad said, part of this is going to be a timing issue. So with respect to the threat of the coronavirus, the problem is, are we going to be really through with this in 1 month, 2 months, 6 months, a year? So a lot of this may need to be postponed for a longer period than we would like. But at least currently, in my opinion, you absolutely have the right to postpone that meeting.
And I would add, just from a practical point of view, businesses are going to find they can't go back to doing it the way we did it literally just 90 days ago. And communities are going to find the same way, as we may have to come up with some alternatives in terms of how we handle annual meetings. Do I know what that is today? I don't. but we may end up all having to figure it out how to do it differently.
By the way, so everybody understands how strong I am in that opinion, I'm going to read to you 720.316. This is the Association Emergency Powers Act that we talked about a little bit earlier about. And by the way, you have them for condos and co-ops as well. And under 1B, one of those powers is to cancel and reschedule an association meeting. That's right in the law. That's what's been adopted, okay? I do want to talk about one other thing now. It's one of the things that's been bothering me. And when we were talking about, because we just got done dealing with the gate thing again, you know, opening the gates versus closing the gates and keeping people out. One of the issues that if we're going to, one of the reasons I want you to be very conscious of talking to your attorneys about, and this is like literally under the statute as well. We're still under 72306, and this is going to be 1G. I want to read it and explain what the impact of this is. It says, based upon the advice of emergency management officials or upon the advice of licensed professionals retained by the board, determine any portion of the association property available for entry or occupancy by owners or their family members, tenants, guests, agents, or invitees to protect their health, safety, and welfare. Now, I want to talk about this in two respects. Number one, we're talking about the access and cutting people off, like in your instance with your family member. Part of the problem is this is saying, yes, you can do it, but look at the conditions under which it's done. Based upon advice of emergency management officials or advice of licensed professionals retained by the board. Is that a condition precedent to associations restricting everybody carte blanche from coming into the community or coming into a condo? Really, maybe. So that's one of the reasons I really want people to, when they're dealing with these issues, to talk to their attorneys so that they can get good legal advice, and hopefully their attorneys are well versed on what's happening on this. The other reason I raised that, though, is one of the things I wanted everybody to hear is about closing. Hope everyone heard, we recommend you close the areas where people are congregating. Great. Does that mean the board can't be challenged on it? No. Back to the language. Does the association, before it closes those things, have to have advice of emergency management officials or advice of licensed professionals? Someone can make that argument. I disagree, but the reason I disagree is because of a higher duty, and that's the health, safety, and welfare. But I did want to point that out in case someone throws it in your face. Arlene?
Lynn Abbey of Spanish Oaks Condominium Association. There are associations considering a proposal to establish one-at-a-time reservation sign-up for the laundry room. They will not, however, have any ability to enforce one at a time, and there might be liability. I'm going to summarize the rest of it. What are the repercussions, the pros, and the cons?
On a laundry room, yes, we've already dealt with this, okay? I mentioned the elevators, but laundry rooms have already come up. Do we recommend one at a time? Yes. The exceptions that you may want to put in place, though, is one at a time, unless there's accompanied by a healthcare professional. Think of somebody if someone has a disability or something like that. And number two, you may even expand it a little more to be one person and family members. But the problem that you're facing here is, and what we focus on is stopping people from going to common areas and common elements. There's another category in terms of restricting the use of those. With respect to implementing the rule, all you can do is implement the rule, post a sign, notify the owners, explain why. Once you've done that, can you monitor it 24/7? No. What you've done is the practical effectuation of what the board can do to try to protect its residents, being responsible, pointing out the danger to people, and implementing a rule that helps to curtail that danger. In my opinion, that's where you want to go on laundry rooms. Now, the other issue is how big is a laundry room? I mean, if you've got a 60-foot auditorium with 40 washers and dryers, that may change it. Most of these laundry rooms that we're coming and dealing with our clients are relatively small. And yes, while you may not want to preclude the use of them because people, where else are they going to get their laundry done? I think you do want to restrict their use.
I agree. You heard me mention earlier in the discussion that you don't want to put a rule in place you can't enforce. With that said, you do need to put some common practices in place or practices in place that protect the community. And I agree with everything Neal said. The only thing I would add, for what it's worth, you may want to include in your notice how often the community is cleaning or not cleaning that area, so that the folks that do decide to use that area they're on notice as to how often it is being cleaned, whether it's once a day, once a week, and that, that folks frankly take the risk that they want to take as they go into those areas.
And lastly on that, if you can, of course, step up your cleaning of those areas, because you know they're going to come under use, and there are going to be people handling things. The other thing you should consider doing is encouraging the owners that are using them to bring their own sanitation so that they can wipe it down for the next person's use, and owners, when they walk in, wipe it down before you use it. These are just practical considerations. These aren't legal issues. That aspect of recommending that practice, that protocol, is not something that's legally required. It's something that's practically necessary, just like the social distancing.
Yeah, it goes back to some comments around emergency preparedness. When a hurricane's coming, the whole community takes action if it's going to ultimately have success. And this is no different. Wiping it down when you're done, wiping it down before you start. Those are all actions that everyone in the community can take and ultimately prevent someone in the building from contracting and spreading the virus.
Okay, Leah Keeney has a question. This is probably directed to Brad. Their 55 and older community has a high percentage of folks who are not technically adept, including some of the board members. How do we navigate the summer without a viable email list, website to communicate with members?
That's a challenge. I don't disagree with you, and certainly we're familiar with that challenge, and I suspect there's many communities in the same position. And not to pick on my own mother, I provide a lot of assistance with her and some of the technical components that you're talking about. And so, if that's a challenge, it's a little slower, but ultimately there's other options. Certainly mailings that can go out here locally. Most mailings that go out, on a certain day are received within a day or two. I recognize that, documents and papers going through the mail come with another level of risk, with additional people touching it. But, getting it out in that fashion is important. Certainly, we've had some smaller communities that are 55 plus have a phone tree in place. A lot of those folks are home. They talk to their neighbors on a regular basis, and getting a phone tree in place, an old-fashioned way, just make sure that each time that message makes it down the telephone chain, it's not changing. And so keeping the message in those cases as simple as possible, or more importantly, communicating where people can get the information is critical. So those are challenges, where a lot of folks just don't have the comfort of using the technology, and that's just email. If you take it to the next level of using a GoToMeeting, and having folks log in and utilize that can be even more challenging. So you've got to go to where folks are comfortable. And sometimes right now that's going to be the mail. It's going to be telephone, and getting those communications out. If it's a smaller community, and some of my managers may be upset with me, but if it's a, particularly 10, 20 unit community, we've had managers trying to call each person within those communities. If you start getting to 100, 150, that's just not possible. But where it's smaller, we're trying to pitch in and make sure that communications continue and folks understand what amenities they can and can't use as they try and use those.
A couple things on that. Consider, because one of the things when you're posting your notices now may be a little bit different than they used to be. You may be, even using like a big, poster board. And on the poster board, here's step by step how you do it. Okay, that's one. Also, a lot of people that may not be comfortable with technology may still be okay with email. All right. What you might be able to do is do as much notice as you can and give alternatives. If you don't know this, call this number to talk to this person to walk you through it. You could also say, if you're literally just comfortable with email and you're going to use like a GoToMeeting or something like that, hey, go to, post a YouTube video of where they can learn how to do it. What you're trying to do is facilitate getting out the information to everybody, but that's also not always going to be possible. At times you may just have to rely and say, we're going to do the best we can, and that's it. It's not perfect. It's not great. Nothing about this situation is. So in that, posting instructions, having maybe a call-in number where they can get instructions, literally have step-by-step on a poster board that's posted, pointing people to go to a particular YouTube video on how to do this or creating your own. All these things may help, but it will not be a panacea. Just do the best you can, and that's it.
And I didn't think about it in terms of the 55 plus, but one area that we do have is some of our communities have engaged us to utilize a voicemail box that we have, and folks can call in. They're given the number to call. They're given the specific extension that we've set up, and there's a voicemail that they can call into and listen to a very specific voicemail versus getting an email. And most folks have a high level of comfort of doing that. And I suspect most of your management companies out there, they have additional extensions that they don't use that they could assign to a community and leave a voicemail.
And this is for either. People go ahead and submit your questions. A lot of these questions we're receiving are duplicates of issues that have already been covered. So if you do have any new issues, that would really help. But the question up here right now, since we can delay annual meetings, are we to presume the board members continue to serve during the delayed time period, despite the fact that their term is up?
I'll give that one to you.
The answer is yes.
Yeah.
Understand, even without the coronavirus, sometimes a meeting cannot be held. You don't meet the threshold for a quorum. Even condos, you have to have a certain percentage of people that vote to be able to elect new board members. Because of that, understand that your board members remain in office unless and until new board members are elected, or B, they resign. And if they resign, or if someone goes off the board and you need to appoint someone, the remaining board members can appoint a replacement. The interesting thing about this statute and the development of this law is even if you go down to one board member, which by definition can't be a quorum, okay, in that event, that one board member can replace the other board members. So he can literally appoint replacement board members as long as you have one. But to answer your question specifically, yes, they just remain in office unless and until someone resigns, in which case they can appoint, or B, you are able to effectuate your meeting. Okay?
Okay, would you recommend encouraging homeowners for prepaying the final 8 months of HOA dues for a 5 to 10% discount?
Yeah.
We don't recommend that. I'm not going to tell you we don't have boards that take such actions, whether it be regular assessments or sometimes even special assessments, and certainly there are state law and documents dependent, and I'll let Neal cover that. But, we recognize the why on that. I'm not going to tell you it's may not be a feasible approach in terms of particularly cash-strapped communities that really need the cash, but I think there becomes some equal protection issues there, and that's a whole much bigger discussion. But even from just a pure practical matter, it's not something we recommend.
Let's make sure that everybody can hate me and my firm now, because the answer is absolutely not. Understand, technically you should not be doing this. This creates all sorts of problems and risk. Understand, almost all the documents out there, and by statute, especially for condos, okay, think of it this way. You have a methodology under the documents, and for condos by statute as well, and co-ops, by the way, that specifies a methodology of assessing. Those assessments are basically uniform. So like it's per unit or square footage, even for a condo. So think of it that way. What you are doing by doing this is assessing at a different percentage per person, which is not going to be allowed, at least by your documents, and probably by, well, at least by 718 as well. You can't do this. If you do this, you are opening up yourself to challenges that the assessment is improper, invalid. We go on and on, opening up to lawsuits. You're giving a defense in case the association tries to collect. You are creating a nightmare, all right? Not to mention, when you go forward, you're going to open it up for Fair Debt Collection Practices Act issues. I can go on and on and on. do not do this under any circumstance. That's as clear as I can be on it. And yes, everybody can hate me, but our job is to protect you. This is how we protect you. Top of that, you're going to run into problems with credibility when you do this. It may seem like a good Samaritan thing. A lot of people want this. Do not do it.
Denise Fish of Tika Village has a question. What can they do with a board member who refuses to meet via telephone or go to meeting? Any suggestions on how to handle that?
Well, is the board member required to hold the meeting? Would be the first question I have. I don't know what's in that document, so I'm answering a little bit in a vacuum. Certain boards, the conditions for them to meet do not require the attendance of every board member at every meeting, and so I don't understand folks that have that level of stubbornness from a particular practical point of view right now. The board has responsibilities, fiduciary responsibilities to the community to make sure that the business continues. And certainly that person may be opening themselves up personally to some real issues if they are without good reason not attending a board meeting, what ultimately prevents the board from meeting further. And so it may be an area where the association attorney needs to lean on that board member and let them know what legal challenges may be ahead for the board member for not attending. I don't know where you want to speak to that.
Well, first of all, you can't force the board member to attend. So if he chooses not to attend, that will be his choice. Doesn't mean it doesn't come with potential legal ramifications, potential legal risk, as mentioned by Brad on the fiduciary duty aspect. However, think of it this way. With this question, what we don't know is, do you need that board member to constitute a quorum? If you don't need that board member to constitute a quorum, he's not there, move on. You have a quorum, you can do business. It's unfortunate, but you can go forward. What do you do if you don't have a quorum? Well, if you don't have a quorum, this relates back to a lot of the stuff I discussed earlier. You have a duty probably to get your business done. You may be forced into an emergency situation. You may need to make decisions. The fact that one board member may not participate and put the association in a degree of peril because he won't attend does not mean that the board can't take action. This may force you to hold a board meeting with less than a quorum. Do I like that? No. But do I prefer that over one board member just unilaterally making decisions if you have not delegated the authority? Okay? So the point being, you're still going to need to do business. You may need to do it under an emergency basis. You may have to do it without a quorum because you're forced into it, and the best you can do is the most board members that you can get there to make the decision. Not a good answer. It's terrible. Should not occur. And I concur that really what you probably want to do is have the your law firm's attorney potentially talk to the board member, because not only is he creating risk for the association, he's creating risk for himself. He's got a fiduciary duty. If there's a reason that he can't do it, then in that event, what may need to occur is have him resign so that the rest of the board members can appoint a replacement board member. Understand, in the replacement of a board member, you don't have to have a quorum. If there's not enough board members to constitute a quorum, even one board member, if that's all that's remaining, can appoint replacement board members. So the answer may be, if he doesn't want to do this or can't do it, maybe have him resign so the remainder of the board can appoint a board member who will fulfill this responsibility.
And just to be clear, I'm assuming your answer does not change if it's the president that's not showing up.
Don't care. Okay. And if the president's not showing up, the issue then is, again, the board may, because there's a difference between the board members and the president, even though they overlap, they're usually, the president's usually a board member. The point being is usually the president's elected by the board. And if you've delegated the authority to the president to act on behalf of the association, you may need to change up who the president is. Okay? At a duly called and noticed board meeting.
Okay, next question is from Barbara Schultz. She's a manager. For post-COVID-19 cleanup before reopening of those facilities, what should associations be doing now to plan, and should we hire professionals who deal with sanitizing?
That question is difficult from the perspective of I'm not sure there's a day that it just ends. And so if there was a day that it just ends, it makes life a lot easier that you could say, hey, on July 1, we need to get everything cleaned up and it's available for everyone's use. I certainly think that it would be good practice that as our society gets back to a more normal, life, and people start to use those amenities, that you do address the fact that it has been sanitized, but that as folks start to use it, we all need to be careful, and that some continuation of sanitization will continue until it's no longer necessary on some regular basis. But to take an approach that on this day, as long as we sanitize, we're good from there on out, I don't think will be the reality of what we see happening over the 2 and 3 and 4 months from now as we hopefully start to wind down from this virus.
Ultimately, there's probably companies that are better suited for properly sanitizing and eradicating this virus from services. Sure, those companies, probably professional companies that exist, same type of stuff with like toxic mold and all that. Be that as it may, is there an advantage of that? Yes. Do you need to do it? Maybe not. Where do you want to be looking for guidance? Probably not from your attorney. You probably even want to be looking to the CDC and the healthcare professionals. This type of stuff is already to a degree been dealt with in terms of proper sanitization and protocols for doing it. I am confident that they will ever increasingly address this issue as time goes forward with a greater and greater knowledge of how long COVID-19 exists on different surfaces. But ultimately, that's going to be probably a business decision for the board. But at a minimum, I think you want to be following the protocols of the experts.
Lucia Arnaiz is a manager of a large condominium association, and they have a large amount of tenants moving in and out, and it's a big concern for them. Could you guide them on the best protocol and practice to deal with this?
Okay, well, we're going back to the issue of blocking people. Okay, it's right in line with that exact same thing. This is going to be a balancing, but can you really prohibit them? You're talking about an ownership interest. It's a tenancy. I shouldn't say an ownership interest. It's an interest in the property. And quite frankly, this is probably going to be extremely hard to block. If it gets bad enough where you have enough COVID cases within a community or within a condo in this case, will you be able to potentially block it? Yes, it's possible that you may be able to justify that under the emergency powers that have been granted to associations and their boards. Would I generally recommend that, at least at this time? No. Would it be good for the association to try to solicit the cooperation of their owners so that they know when the people are going to be moving in a condo? For purposes of this question, I'm going to presume it's a high-rise condominium, and as more and more people come in, they are touching things and exposing things and having more people in smaller spaces where the other owners and tenants may be passing them. The other thing is requesting that those people wear face masks, these type of thing, or bandanas or whatever, something to help inhibit the spread of COVID-19. Also, if you can encourage those people to apprise the association of the time they're going to be doing it, then in that event, the association may be able to effectuate better cleanup and sterilization after they've gone. Lastly, by trying to schedule it, the association may be able to have it to where you don't have multiple people moving in at one time and really putting a heavy strain on the use of the elevators, especially to the extent that you're going to only want one person in the elevator at any time and you'd prefer it to be wiped down. Can the association potentially implement a rule that only one move-in can be happening at any one time? Yes, possibly. Why? because again, what is the strain on the facilities and the amount of people in an area where people will congregate? Think of the area right before the elevator. What if you have two companies trying to move in at the same time, or one moving in and one moving out? This can become a real strain on the environment that the association has. So more of this is probably going to be by trying to regulate it than prohibit it.
Yeah, the only piece that I would probably add to that is, Neal talked about protocols earlier and what protocols people have to enter the building. And communicating, we go back to that, communicating in advance, these are the protocols that any move-in company or new tenant absolutely must follow if they're going to move in, and certainly time slots and the sort. One option, and maybe one of those protocols, is they have a responsibility to hire a cleaning crew to cover certain components of the building, and you may be able to extend that expense. But this is the only cleaning companies that are allowed to be hired to do this, and this is the price they charge, and is now a component of the move-in during these times.
Think about it this way: when you start entering elevators, you have handrails, you have the buttons, you have the doors leading into the area a lot of times where the elevators are located. These protocols are becoming more and more important, and advising the owners to be aware of those surfaces and to take precautions with touching those surfaces and taking extra precautions to have them sanitized more frequently is the efforts that the association should be undertaking. Unfortunately, this is never going to be a panacea. You're not going to be able to completely control this. You don't have guards there 24/7. So the best you can do is notify the owners, solicit their cooperation, put it into place and advise them of what they should be doing, as well as how they should be assisting in the protection of the other residents.
Okay, we've probably come to the end of our questions. One of the biggest questions we were receiving over and over again, was this webinar recorded? Yes, it was. And we will send you the link to be able to view the webinar later. And now I'd like to turn it back over to our very distinguished speakers for their closing remarks.
Go, Brett.
Hey, thank you, and thank you for inviting us into what's likely your homes today, and hopefully you've gotten some great information, at least a nugget or two that'll help guide you as a board. If I was to give one last piece of advice, it would tell you that not every decision you make right now is going to be popular. And you may even have some folks call you some really ugly names in terms of shutting down amenities. And just know that you have the authority as the board to make these decisions. You're doing the right thing on behalf of your community, as long as you're being sensible with them, and not to get into email and social media spats. Make a decision, make good sound decisions with good advice from your attorney, collections team, management company, vendors, and then trust those were good decisions that you've made as a board.
First, I want to thank Brad. Thank you so much for coming here today, taking your time. I know how busy you are to put this on. I hope it was helpful to everybody. Our firm stands ready to help our clients. Anybody that needs our help on this, believe it or not, yes, we're still at the office. We're an indispensable type of entity, I guess, and therefore we're here to service our clients and handle all their needs during this hard time. I do want to point out something that it's along the line of what Brad was talking about. You're going to have to make some hard decisions, and you're probably going to take some heat. I can't tell you how many of my associations are taking heat for closing their amenities. It is an unfortunate circumstance. But in doing so, one of the things I will recommend is, especially my clients, blame me. Blame Clayton-McCulloh. When we are giving our clients advice and you're following our advice, do not take it on your shoulders. Literally point out the reason we're doing this is on advice of our counsel. This is what we've been instructed to do. This is what reduces our risk. This is what fulfills our fiduciary duty. understand that's part and parcel to the whole concept of when you're doing these notices and making these motions, putting this information out there for a credibility standpoint. We don't want you to lose credibility. And on behalf of Clayton-McCulloh, I just want to thank you all for attending. We will try to put on another one of these. We don't have an exact date. We only talked about it right before we opened this because so many people were attending and there were so many questions. I hope it was helpful, and thank you on behalf of Clayton-McCulloh. Thank you.